Dominion attributed the pipeline's demise to ongoing delays and increasing cost uncertainty, which threatened the economic viability of the project. Specifically, the company pointed to a string of legal challenges to federal and state permits the pipeline had received but then saw yanked. The price tag had risen from $4.5 billion to $8 billion. Dominion Energy CEO Tom Farrell told investors to state the obvious: permitting for investment in gas transmission and storage has become increasingly litigious, uncertain, and costly. He added that this trend, though deeply concerning for our country's economic growth and energy security, is a new reality. So what is your reaction to Dominion's point of view? We can start with you.
Okay, my reaction goes back to 2014, obviously, when we began the fight with Dominion over the pipeline. And when we first got together with the Friends of Nelson, you know, one of the things that I had laid out for people is that as an attorney, our job is never ethically to delay it for the sake of delay. However, what we said was that you have the right as citizens to use all of the available environmental litigation and laws and regulations to your advantage to make sure that the pipeline, if and when it is constructed, meets the environmental requirements that the federal and state government have set forth. And I believe that one of the things we pointed out and discussed was that that could take a very long time. And quite honestly, it was my belief then, as it is today, that the longer it takes to go through that process, two things are going to happen. One is that hopefully you're going to get better environmental documents that will address the issues that need to be addressed and address them fully. And then the other is it gives an opportunity for the public to really participate in the administrative process as well as the potentially ultimate litigation process, and that whole program can take a very long time. And I think one of the things that we talked about back in the early days was the fact that the longer it takes, the greater the likelihood is that something will intervene along the way. Something intervening could be the economy. Something intervening could be a change in the membership of FERC. A new president comes in and totally redoes FERC, giving it perhaps a different view of pipelines and fossil fuels as opposed to energy that comes from the sun and the wind and so forth. So my reaction to this is, yeah, the price did go up. You know, look at the price of lumber that we were just talking about. The price of lumber has gone up. And litigation certainly played an important role in this, but that role was not necessarily to extend it, but rather to ensure that it met the laws that were out there to protect the people and the environment. Great.
So that was a really good answer. What I would add to that is Dominion, these statements from Dominion don't really account for Dominion's own responsibility in how it began this project and where it tried to put it. And specifically what I mean is it was a major gas pipeline proposed through the steepest mountains in the region across protected federal lands. It would have affected threatened and endangered species and their habitat, and it would have affected environmental justice communities in Union Hill and elsewhere along the route. So it's not surprising to me that the project ran into serious problems, and I think for all of us, the folks in Friends of Nelson and in ABRA and all the groups opposing the project, it was never surprising that there were going to be serious problems developed with the proposal and that the project ran into delays and hurdles, given how it was planned and where it was planned to go. you know, one thing that emerged in the litigation was the fact that Dominion used its political power, its political influence to pressure agencies to issue permits, to cut corners on legal requirements, to accelerate timelines beyond the timeline the agency thought was possible. And I think that's an additional reason that all those permits ran into serious problems.
Thank you. How did public opposition to the ACP by FON, by ABRA, AppleMad, whoever, you know, Friends of Wintergreen and so on, and many other groups, how did that public opposition contribute to the defeat of the pipeline, and how did it connect to the legal fight?
My view on that is that one of the things that happened was there was a huge amount of public opinion and organizations coming together early on in the process. It did not take long for the people of Nelson to rally once everybody started getting the notifications that the pipeline was going to come through their property or their neighbor's property. And I think that one of the important things for the viewers to understand perhaps is that the more different organizations that you can get to come together from the communities that are going to be impacted, all the way from West Virginia to North Carolina, the better off you are, because they all come at it from a different perspective. They all have potentially a different source of income. Money becomes important. One of the first things I remember talking to the Friends of Nelson about was, we're going to need for you to start thinking about how you're going to raise money. You're going to have to become a corporation so that, you know, Dominion doesn't ultimately sue you guys as individuals and try to scare you away. But raising money was important because we knew that we were going to have expert witnesses along the way, and those experts were not going to necessarily all be free, and so having different organizations is really, really important. The other comment I'll make about different organizations is that different organizations have a different approach. The Friends of Nelson and ABRA you know, really kind of came together as a community and fought for the community. And then there was another organization, which I can't remember right now, but it was an organization that raised a lot of money, and their approach was to use public relations and to use more of access to their own government officials at a high level, trying to go in and getting those people to slow this thing down and take a harder look and maybe talk to Dominion and maybe even, you know, consider alternatives. One of the things that never happened, in my opinion, which I still do not understand, is that there were a couple of organizations that approached Dominion and approached leadership in Dominion and in the state of Virginia and said, we're willing to propose some alternative routes. And Dominion simply was not interested. They never responded. And as a result, they ended up losing the whole pipeline.
It was just absolutely essential that Friends of Nelson and ABRA and all the other groups got together in a big coalition. And everybody, I think Rick is exactly right. The groups all had different approaches that they were taking, but the coalition provided a vehicle for everybody to get on message, to understand what the strategy was, and to focus at critical moments. And I think probably the thing that stands out for me the most is after the Fourth Circuit threw out the Forest Service permit and said the Forest Service didn't have the legal authority to allow the pipeline to cross the Appalachian Trail, Dominion went to Congress and said, we want a law, we want a rider. And they had two sentences. The company had two sentences it was trying to inject into any bill in Washington language, any train leaving the station, any piece of legislation that was going to move, they wanted to stick this rider in. And the ABRA coalition and all the member groups got organized, called their representatives, called their senators, and that didn't happen. Dominion was never successful in getting that legislation passed. And there are dozens of examples like that of the power of a unified coalition. Lou Freeman, who ran the ABRA coalition, made sure to make that an inclusive tent, right? So everybody was a member and participating in those discussions, even if their individual strategies were different and approaches were different.
Gotcha. So there were a number of cases in which SELC was the lead counsel in the Fourth Circuit, and one was Cowpasture River Association versus the Forest Service, which was in regard to construction permit issued by the Forest Service that would have allowed Dominion to construct ACP, and you were just probably talking about this very thing. But could you summarize what that case was about and what the impact on the construction of the ACP was?
Yeah, well, one of the things that was so just a great opportunity for stopping ACP was the fact that Dominion was going to put it through 2 national forests and across the Blue Ridge Parkway and the Appalachian Trail. And those are protected pieces of federal property, and they have special laws that apply. And so the Forest Service eventually issued a permit under pressure, and you'll remember the Forest Service was initially very skeptical of this project, and when the 2016 election happened, after that election, the agency got political pressure from Washington, issued a permit. We challenged that permit, and there were a number of claims in there. One of, and as Rick talked about earlier, several of the claims had to do with how the Forest Service conducted its environmental review of the impacts of the project, and in particular landslides and sedimentation and erosion were, we argued, were not adequately addressed. We were helped out a lot by the record the Forest Service had created. The supervisor of the Monongahela, Clyde Thompson, all the way up until he was basically shut down by political appointees in Washington, was writing letters that said, was saying things like, I'm very concerned we'll be able to keep the pipeline on the mountainside and the mountain on the mountainside. And not surprisingly, right, it's just incredibly steep. And so one of the other issues was this unique issue, legal issue about who had authority, what agency had authority to allow the pipeline to cross the Appalachian Trail. So we were the lead on that case. We presented it to the Fourth Circuit, argued that in September of 2018, and then the court threw out the Forest Service permit in December, mid-December 2018, and just before that, the court had issued a ruling in another case, the case against the Fish and Wildlife Service, and together those 2 decisions stopped all construction. So construction never started up again after mid-December 2018.
Very good. Do you want to add
No.
anything to that?
Well, that's all about Greg.
All right. So SELC did file a brief and presented oral argument in the Fourth Circuit. What was that argument for the Fish and Wildlife?
Yeah, so we argued, we ended up filing 8 cases. We co-counseled some of them with one case we co-counseled with lawyers at the Chesapeake Bay Foundation. We co-counseled several with the folks at Appalachian Mountain Advocates. We actually co-counseled the Forest Service case with a lawyer at the Sierra Club. And all of those cases, all except one, went to the Fourth Circuit. One of those cases went to the DC Circuit. And in fact, that case is still pending. That was a challenge to the FERC permit, the FERC certificate for the Atlantic Coast Pipeline, We were scheduled to argue that, my colleague Mark Sabbath was going to argue that in the DC circuit in October of 2019. 2 weeks before the argument, the Supreme Court took up the cow pasture case, and the DC circuit, the lower court, said, well, we're not going to do anything. We're going to put this case on ice until the Supreme Court issues its decision. Of course, fast forward to 2020, the Supreme Court issues a ruling in the cow pasture case, but the project gets canceled, and now we're just we're waiting until the FERC certificate, the FERC process about restoring the right of way is concluded, and then our case will be dismissed.
Right.
So we never argued that case, but we argued the rest in the Fourth Circuit, and we ended up getting 6 wins in the Fourth Circuit.
Let me jump in, Woody, and give you some perspective on what that means to the folks that might be viewing this in the future. One of the things that strikes me is that those community organizations that came together to fight the pipeline were very fortunate to have the Southern Environmental Law Center as their lead counsel, and to have them be here in our community representing the forest, the mountains, the environment. Without that, I doubt very much whether we would have been successful, because even though I'm an environmental lawyer, I knew right away that this was way bigger than any one individual lawyer could handle. When you're up against the Dominion powerhouse lawyers that are both in-house and what we call out-house lawyers, they have tons of money, they have lots of power, they have lots of paralegals, and they can spend an inordinate amount of time in litigation. So, you know, Greg and SELC did an outstanding job, but even with just them, I think that having the benefit of Chesapeake Bay Foundation, the Sierra Club, and other counsel, the folks from West Virginia that you mentioned, I think that the overall legal team that came together was pretty formidable and was definitely up to the task. So I think that's a real key issue. If you're faced with something like this, you need to be able to somehow either afford those other attorneys or be in the good fortune of having an environmental organization come in and come to the rescue.
Yeah.
And this was unlike any project I'd ever worked on before. And I quickly, with the help of my office director, who was always looking down the road, seeing what was coming, we realized that we were going to, our staff at SELC needed to be bigger. And so we brought in my colleagues from Asheville, who are public lands experts. We worked, folks in our Chapel Hill office worked on this project, most notably the Union Hill compressor station. Folks in DC worked on things happening in Washington DC. So this started out as an assignment for me, but it was so many. There were so many moving parts. We built a team at SELC with our friends at these other organizations to take on all these different aspects of the project.
One of the things also that I'll mention, and again, I think this is important for other folks that may be listening, and that is that none of us, when we started, were really experts in FERC law, because FERC law is different. The National Environmental Policy Act, Clean Water Act, the Endangered Species Act, they all apply to every federal agency. And they apply to FERC, but because of the unique nature of FERC, they apply in a little different way. So one of the things that Greg was able to do is bring on some help with people that really had gone through that FERC process before and that at least understood the administrative ramifications of what was going on.
Yeah. So the case that is in question number 6 is now on hold, essentially, right?
Yeah, that case,
Would be
right, so that case is actually still on the books.
Mhm.
But as soon as the pipeline, as soon as the proceedings at FERC are over,
Mhm.
then that case will be dismissed.
Okay.
So it is still on the books, but other than a status report, updates to FERC, updates to the court every few months where there's no action.
I have a question for Greg, and it's a procedural question, but I think it's really an important one, again, for potential future viewers. And that is, one of the things that Greg and I talk, we got together every once in a while, and we would brainstorm about NEPA and how to approach this and where to go and, you know, how to do this, that, and the other thing. And one of the things we talked about early on in the game was, where do you file your case? Is it the Fourth Circuit Court of Appeals or is it the DC Circuit? Because for years and years, most of the early environmental law was created in the District of Columbia Court of Appeals. And it has a pretty liberal record back in those days. Fourth Circuit, not so much. And so I'm curious about, at the end of the day, how did you guys decide to go to the Fourth Circuit primarily?
Well, it's an interesting question. That was the choice for these other permits, these other permits from other agencies. The Fourth Circuit was our choice, so we had to go there for like the Forest Service case. We actually filed our case against FERC in the Fourth Circuit, but Atlantic Coast Pipeline filed its own challenge. It challenged its own FERC certificate in the DC Circuit, and so the venue got resolved in favor of the DC Circuit. And that was disappointing. We'd already won some cases in the Fourth Circuit. We wanted to be there,
I don't blame you.
but you know, we pulled a good panel in DC, and we've seen in the last couple of years the DC Circuit issuing some really good rulings on pipeline cases. So I after getting over that initial disappointment of being pulled into DC, we were off and running. I mean, we had a live case and in front of a court and a chance to win, and we weren't certainly going to give up.
There was also a potential appeal to the Fourth Circuit to challenge the failure of the Army Corps of Engineers to require compliance with Nelson County's floodplain ordinance under Nationwide Permit 12. Do you know what the gist of that case is, and could you kind of update us on that?
Yeah, I'll have to reach back into the memory vaults. But so this case was never filed, but the project intended to rely on Nationwide Permit 12, this general permit from the Corps of Engineers, and in Nationwide Permit 12, one of the conditions of Nationwide Permit 12 is that the pipeline comply with all local zoning ordinances. All local floodplain ordinances. And so we knew that Dominion Atlantic Coast Pipeline wasn't going to comply with the floodplain ordinance here in Nelson County. And so we alerted the Corps to that issue, and our plan, what the potential we saw was the Corps was going to ignore our letter and authorize the project under Nationwide Permit 12, and then we would have presented an issue to the agency that we could then take to court. And so the Nelson floodplain issue was, the community cared a great deal about it. I think it was an incredibly important issue. The challenge, for several years, the challenge in my mind had been how to overcome federal preemption, right? The Natural Gas Act preempts local and state and local laws, but it turns out there was this condition in one of the other permits that the pipeline was going to get that provided a tool.
One of my I was on the Board of Supervisors here years ago, and one of my first reactions to hearing about ACP is that it makes a joke out of Nelson County's entire zoning ordinance. because why would you have an what amounts to an industrial use in an agricultural zone, or maybe even a residential zone? It just made no sense to me. Now, I understand that federal laws can override sometimes local laws, but it makes it much harder to argue then that we're gonna develop our own comprehensive plan and we're gonna do our own set of zoning ordinances and so on. And by the way, Nelson County had no zoning until Camille happened.
Oh, wow. Yeah.
And it
I
had no
didn't realize
floodplain ordinance
Yeah.
until Camille happened. So, and I wasn't on the board when that happened, but there was a residue of that whole thing still percolating through zoning decisions and appeals and things like that when I was on board of supervisors. And arguing where the floodplain really is. Is it where Camille was or where normal rain, might get you. So it just, Vicki Wheaton's work on getting us to comply with FEMA regulations and things like that, we're hopefully gonna interview her fairly soon.
Oh, good, yeah.
Because I think she played a very important role in what Ernie Reed considered to be our last stand.
Yeah, sure.
Had everything else collapsed, maybe this was something that could still block it.
But I think that's true, and I think that brings up the point that, again, from West Virginia all the way down to North Carolina, there were a lot of active local Board of Supervisors and local government officials that really supported the environmental organizations. And I found it very interesting how in a rural area, which is not perhaps known for being environmentally totally sensitive, that when somebody like the federal government comes in and they start talking about taking your land, that brings together this coalition of folks at the citizen level and at the supervisor or local county government level. And all of a sudden you've got just one more layer of people that are saying, well, let's not go so fast here. Let's take a hard look, let's slow this thing down, and let's make sure it's done right, if it's going to be done at all. So I think that the various boards of supervisors, generally speaking, were very important, and especially in Nelson County.
Yeah, this is one of the few cases that I can remember from my 45 some odd years in Nelson County where property rights advocates got together with environmentalists and said, we're on the same side.
We're on the same
I
side.
wish that would happen more often, but.
Well, that leads right into my next question, if I can follow that. The property rights and the domain versus environmental issues. If we, speaking of friends of Nelson, if we got carried away in the environmental issues, all the right was saying, oh, it's the liberal, hippie environmentalists. And if we got over on the eminent domain side, people said, well, they don't care about private property. We had to balance that. But all the wins were on environmental issues. All the money was on property rights. How do you advise, what should I be telling another community how to handle this issue?
I don't know, Greg, what's your thought on that? I mean, I think that, I'll give a very brief thought, having dealt with a little bit of an eminent domain in my former life. And that is, it's very hard to win on an eminent domain case, especially against FERC, because they can kind of do what they have to do. And so, in essence, I personally and the folks at SELC didn't get involved in that, because that's really a private property issue between Dominion and the people that own the land that they were going to go through. And it's maybe harsh to put it in that light, but I think that's the reality. And we knew, I think we knew that our best shot was in the environmental side. We were never going to stop this from the eminent domain perspective. That was just not going to happen.
But the slowing down, did that come from the environmentalists or the property rights? Because on the blocking the ability for them to go in and do early surveys. That fight over, they had to take us to court in order to even do their survey, was a great delay in this county, whereas some other counties it just went on through. Did that give more time to the environmentalists?
I think all of those things did have an aggregate effect of slowing this project down. So it's hard to pinpoint any one thing, especially in those early years, but Dominion was running into problems executing its plan. That was, delay for delay's sake was never the objective. It was, at least for our work, was to require compliance with the law. But those early hurdles, I think, were helpful. Sometimes I've heard the strategy described as 1,000 cuts, right? And I want to, and I think there's some truth to that. The strategy we put together is a little more nuanced. We specifically, you all remember that FERC would issue certificates. When this first came down, the lay of the land was first FERC would approve a project, but you couldn't get into court to challenge it for months, in some cases years, but the pipeline would get built. And so there were the few examples we could find of opponents beating FERC. The pipeline had already been built and was operational. So that was the issue we needed to take head on. And so the other permits gave us an opportunity to, we set about to stop construction to preserve the status quo in order to get FERC into court. And I think what's almost ironic about our strategy is we're still in court against FERC. That case will never get resolved, but the strategy worked in that the pipeline got defeated. So we intentionally with our case selection attempted to stop construction because we knew if this project got too far along, it was going to be really hard to unwind it, even if we ultimately could win against FERC or some other agency.
Because one of the things that we talked about early on, when the first couple of meetings that we ever got together with the Friends of Nelson, and we would talk about the fact that NEPA in and of itself is not going to win this case. It will require them to comply with the law and do a good environmental impact statement and talk about alternatives and do all those things. But the NEPA law does not provide really for a permanent injunction on a proposed action, i.e. the pipeline. The Endangered Species Act does, and if you don't get an NPDES permit, you can't build your project. So those other laws had more teeth, if you will, in terms of really stopping the pipeline from going forward. And so you have to look at all of them together and use each and every one as best you can, whether it's the wetlands section of the Clean Water Act or an air pollution permit or the environmental justice. I mean, I think at the end of the day, right there at the end, that whole environmental justice thing that the governor kind of hosed up on behalf of the state, I think that really had a big impact. I mean, there was a lot of public outcry and a lot of focus back on the pipeline, which it had lost its public steam, so to speak, but that really energized the public again and really ticked off a lot of people. So yeah, each and every one of those aspects was really critical to the ultimate win.
And we knew, we picked two cases, we led with two cases which were purely legal. So they were, we rushed them to get, so the construction, you probably remember, construction started February into March of 2018. We filed two cases in January, we rushed them So we got on the May docket before the Fourth Circuit. They teed up questions of law that the court didn't have, could really grapple with without a lot of factual background. And the strategy there was to get in court as fast as possible and get a decision as fast as possible. And my colleagues, in order to accomplish that, we agreed, the way these cases work, you file your opening brief, the other side responds, and then you get a reply. And we agreed, normally you get like 2 weeks to write your reply, but we agreed to a weekend. And my colleagues down in Asheville, were doing jumping jacks so they could stay awake to get that done. They worked all weekend to get that briefs in on the first challenge to the Fish and Wildlife Endangered Species Act permit and the right-of-way grant from the Blue Ridge Parkway. And Rick is exactly right. So we ended up winning both of those cases. The court issued its opinion in August in those cases, but 5 weeks later, those agencies had reissued their permits. So they were, there were procedural problems. The agency says, well, we went back and fixed them, and they reissued the permits. Now we challenged. They didn't really do anything different in those 5 weeks, so we challenged those permits again. But that's the world in which we were living with, which is, no fatal blows until we came to the Appalachian Trail issue, which the Fourth Circuit, from the ruling from the Fourth Circuit on the Appalachian Trail was one of these rare fatal blows that only Congress could fix that, or the Supreme Court.
Yeah. Ron, you got anything else?
Well, the next one is hard for me to articulate. What I'm looking for is a suggestion on how to organize the legal fight from the front, from like Friends of Nelson. We first all had to say, we're not lawyers. You need to go get your lawyer. I mean, everybody was asking all these legal questions, and that was a standard answer. I'm sorry, we can't speak as lawyers. Well, some did. And then we got the lawyers coming in from outside the area, signing up people, and it won't cost you anything, and we'll be your lawyer. And that didn't necessarily help us fight the pipeline. Mm-hmm. In some cases, that took some of our forces and put them in inactivity. We tried at one point having a volunteer lawyer, I think, that was advising people on lawyers. And I still have to evaluate whether that was effective. But I read on Jane Cleave's page now, on the way they're organizing their efforts, is they have a lawyer, and you sign up with some reasonable amount per month, and you get to meet once a month with the lawyer and Jane. And a lot of advice for everybody comes, I guess, from that one lawyer. So I'm looking at how a grassroots group like Friends of Nelson fighting the pipeline should do their lawyering. And I'm thinking, should we hire at the beginning somebody that's not necessarily an eminent domain lawyer, but a good lawyer on things like the survey and the normal legal questions, so that if 50 people have that question, then we just get an answer for 50 people at one time. And if they have an issue that nobody else is interested in, well, then they'd have to pay him extra time or get another lawyer. But for a lot of the stuff in common, could we have a lawyer? And then when we move to the eminent domain, should we look at an eminent domain lawyer that represent everybody? Or should we have a lawyer that can advise people on how to deal with their eminent domain lawyers, so to be sure to include this. But I don't even know how to ask my question, but I think you see my frustration. Any advice?
This will probably sound like a lawyer, but it will depend on in some ways it's going to depend on the circumstances. So I think Rick is right, in in this case, eminent domain was a foregone conclusion, right? You couldn't, the Natural Gas Act says if a pipeline gets a certificate, they have the power of eminent domain. So the district court, there's not a judge in Virginia that's going to ask the question about whether or not the project is needed or is a public necessity. That's been decided by Congress and FERC. And so those eminent domain cases were only about the price. You know, what is this company going to pay you to take your property? And so, you know, as we were thinking, you know, initially, I think everything was on the table, but as we looked at it, it didn't seem like we SELC, and I think it sounds like Rick reached the same conclusion, there wasn't much we could really do about eminent domain. Now, those folks all needed lawyers, right? They needed to get, if this thing was going to be built, they needed to get as much money as possible for their property. So I guess, you know, and I'm not exactly sure what Jane Cleve is dealing with out in Nebraska, but I think the situation, you can imagine the situation being different, right? Where eminent domain is more of a strategy, more of an opportunity to stop a project. It wasn't here for this one, and so we didn't focus on it. We focused on these, and frankly, we're not experts in that area either. We focused on the things we knew and we thought had higher strategic value.
To go a little further, Ron, in answering your question, you know, I'm thinking back to when, you know, the eminent domain lawyers kind of descended upon Nelson County, if you will. And I think it was a distraction. I think that there were a lot of folks in the community, a lot of folks from Friends of Nelson that were more interested in kind of protecting their property than they were looking at the big broad picture. And when I say protecting their property, I'm thinking to myself, I think that in the back of their minds they were thinking they could actually stop eminent domain, even though we knew they couldn't stop eminent domain legally. And you know, some of the lawyers that kind of came in, I think, sold them a bit of a bill of goods on what they could do. And you know, and the reality is when they say it's free, you know, if the government offers you $50,000 and they get you $65,000, their fee is going to come out of that extra $15,000. So it's kind of free, but it's not, there's no free lunch. And so I think that was a bit of a distraction, and I think that we were fortunate. We Friends of Nelson, we ABRA, we the various organizations that were involved in this. I think we were fortunate in that you know, we had SELC that knew what their strengths were, and they knew, you know, they were going to say to you guys, you know, you guys go deal with eminent domain and do whatever you have to do, but we're going to try and deal with permitting and NEPA and the environmental statutes and regulations that we know about, and we're going to try and focus on actually potentially stopping the project, or at least making sure that it went through every legal hoop that it had to go through. And so there was you know, two different important areas to look at. And you know, as Friends of Nelson, I mean, I think that your organization represents a lot of different organizations out there in the United States. You know, you got a lot of volunteers, which is good, but they're volunteers. And everybody comes at it from a little different political perspective. And so somebody who's in charge, I don't know how many heads of the Friends of Nelson there were, but I can think of at least 3 that kind of sat through that chair and you know, went in and out of there for a variety of reasons. And so, it's tough being in that position. And, you know, perhaps one of the things that you could have done early on in the game is to hire an attorney to help you make that distinction and say, okay, eminent domain's over here, that's what those guys are gonna do, and environment's over here, and let SELC and their, you know, lawyer associates handle that aspect. That probably could have caused a lot less angst in the organization perhaps, and a lot less spinning of wheels, because I saw a lot of spinning of wheels over the whole eminent domain issue.
Yes.
Excuse me. So that would be kind of my response, I think.
I mean, it is, you know, I think one thing certainly is true is it is really stressful, right? If you're a landowner and your property is in the crosshairs, you know, it's got to be incredibly stressful. You know, I know anecdotally from taking phone calls from folks, and we're dealing with it now on another proposed pipeline over in eastern Virginia called the Chickahominy pipeline. It disrupts your, you know, the idea that some private company is going to come take your property doesn't seem like it should be allowed. But and I've been down to in the last couple of months, been down to the Mountain Valley pipeline to the right of way where there's been construction. And the thought I had, you know, you don't really get a sense of it from pictures, but the thought I had while I was there is, it is hard for me to believe this is legal. It is so, I can certainly, you know, certainly sympathize with landowners who are facing that issue.
I saw it as a moral dilemma that FON managed to finesse. If you go through the eminent domain process, one of the things that you might negotiate for is put it somewhere else on my property, but that might affect one neighbor versus another.
Mm-hmm.
And that's what happened here actually with proposed route changes and
Yeah.
things like that.
Yeah.
And FON was always, in my mind, and I wasn't on the board at the time that things were going down, trying to maintain that balance that you talked about, where you don't make judgments about people signing an easement.
Mm-hmm.
And actually, most people did sign an easement. The ones that had lawyers probably bid better than the ones who just took what Dominion was
Yeah, I'm sure that's
selling.
true.
But I thought FON tried to be very careful about not making judgments about people's own concern for their own property.
Mm-hmm.
But I think they kept in mind the bigger picture of let's stop the project entirely.
Mm-hmm.
Because wiggling the line doesn't solve the problem.
Right.
Just pushes a problem onto somebody else.
We started out with just about everybody that was a property owner on the route. We ended up, I don't know if we had a property owner on when we ended up. Maybe one.
Oh, still in the organization?
Well, in the organization, I'm talking about it on the board.
On the board, I see.
But when we started out, it was almost 100%
Mm-hmm.
on the route. One other population that we never really did marshal are the people that are the adjoining owners that have no legal standing in the issue. And yet, the effect of the pipeline on their property is almost as bad as those that it goes through. It's just a matter of how many feet different. They were never marshaled. Do you think that would have been another force? And how would that were there any laws that could have helped them?
Well, eminent domain didn't apply to them, and environmental laws applied to everybody. So, you know, from that perspective, if they were concerned, and it would be interesting, I think, to go back and really see how many of those people maybe donated some money, or how many of those people wrote a letter, how many of those people participated in the public process of NEPA. It would be interesting to find that out, and I don't know that there's any possible way to do that. But, if you think back, there were a lot of comments on that document from all walks of life, people. Some in favor, but many, many opposed. And so, I don't know that having them, I guess if there's going to be a benefit, the more people you get on your team, the more people that are members of Friends of Nelson or ABRA or whomever, the more potent it is politically. And let's face it, one of the ways that you go down the road of potentially discouraging this kind of activity is politics. If the politicians in the state of Virginia are not in favor of putting a pipeline where that pipeline was going to go, it would not have happened. And, so I think Greg alluded to that earlier. The more people you have involved in that political process, the stronger your game is. The more potent your political presence is with that organization.
And the limitations of the eminent domain piece of this can be seen in these zombie easements.
Mm-hmm.
I mean, it's
Yeah.
directly affecting a bunch of people,
Sure.
but nobody else is affected by
Right.
it, as far as I can see.
I agree.
What's the SELC has filed statements on that?
Yeah, so we've been, on behalf of all of our clients, commenting on FERC's impact statement for restoration.
Right.
And one of the, the lead issue that we're raising is the zombie easement issue. I'll be candid, I don't know what FERC is going to do. I think there's certainly a good argument that FERC could place a requirement on Dominion to give back these easements or release these easements if a landowner requests. We're charting new territory, right? FERC's never, I think, really been faced with this issue before, at least not at this scale. And so, and there are hints from FERC that it sees the easement issue as a private agreement between Dominion and the landowner. Of course, we know, yes, it is an agreement between Dominion and the landowner with the threat of eminent domain, right?
Exactly.
So, I think there are some problems with FERC's view, but we won't get a definitive answer out of FERC until sometime later this year, I think.
Could there be any strategy to wait and see if a Republican administration is returned to the White House would open up something and somebody else would like to take all those easements?
It is a concern, right, that there's a sort of this ghost pipeline easement, mostly complete, running 600 miles from West Virginia to North Carolina. And so I think that is a concern. It will depend, in some ways it's going to depend on the language of the easement itself, the document, what it can be used for in the future. And there's some variability in the ones that we've looked at. But I'm concerned about it, and that's why why the folks at SELC are talking to our clients at Friends of Nelson and other places keep pushing this issue to see if we can't get some resolution. And I know there are other organizations for whom this is more of a central part of their mission, like the Niskanen Center. And so I think there will be opportunities, I think, to discuss, what, assuming FERC doesn't do what we want, what other steps are out there.
I think one of the benefits is you do have a recent new appointment
Mhm.
from the Biden administration on FERC, which may, provide them with a little more enlightenment. It'll be interesting to see what happens over the next, he's got 3 more years.
Mhm.
So, I think keep your powder dry and keep it right in front of them so that if the majority flips, now is the time to strike and maybe get them to answer that question more positively than if there's another administration.
I remember way back to 2014, this project landed on my desk, and so one of the things, as Rick said, I'd never worked on a FERC pipeline. Rick hadn't worked on a FERC pipeline. We had to figure out what the deal was, before we could start to put together a plan.
What are the ground rules?
Well, you did pretty well.
It worked out okay. I think it did. We all can give ourselves a pat on the back. But it wouldn't have happened without the whole community coming together.
Right.
Friends of Nelson, groups all along, especially concentrated in this western part of Virginia, from Buckingham up to Highland. Those groups came together, stayed focused over. It's really remarkable, right? 6 years.
6 years.
To not. I mean, I know there were highs and lows, but in general, there was a really consistent effort that whole time, and that made the difference.
One of the things we said early on was that this is not going to be a sprint. This is going to be a marathon.
Mhm.
And you've got to recognize that. And every time our organization would get together, we try to reiterate, don't give up. Things are going well. We just filed this lawsuit. Gosh, we won that lawsuit. Oh, we filed 2 more. Wow, we got another good opinion. And it was this process that kept grinding it out and grinding it out. But so often, I think groups, local groups, they want to get in there, get a decision right away and move on. Go back to their normal life. Well, here you guys are 7 years later, and you're still, trying to help out future generations to figure out how did this one work? Why was this one so successful when so many, the vast majority, have not been successful? And so I think that, that's indicative of, it's kind of a Nelson County thing. And obviously there are other counties and other folks that were involved, but, you guys were pretty strong leaders when it came to figuring it all out early on in the game and acting immediately. Not sitting back and waiting for the surveyors and waiting for the eminent domain people to come, you guys didn't do that.
And that's what Ron is hitting at. He wants, first 90 days,
Yeah.
very, very important.
Yeah,
I think it's a race to get to the landhunters before the surveyors do.
I think that's a good point, Ron. Yeah, I agree with you.
I'm sitting here really sort of playing with my own emotions, but to sit here in front of the 2 of you, I think Rick is our prophet. I mean, I can remember some of the things that he said back then, and I know some of our strategy came from that. And all the time, I don't know where the 1,000 cuts came from, and I understand the ethics of the lawyers. You can't say delay is a tactic. But the 1,000 cuts and give the lawyers time to work and put it on the record, on the FERC record, to give it so lawyers can use it. Those are the things that we heard time and time and time. And so that came from our prophet. But you were our savior.
That's right.
And you came in and slayed the dragon. And so it's really a pleasure to sit in front of the 2 of you.
Thank you.
Oh, well, thank you. It's fun to be here.
It is fun to be here.
Yeah, it is.
For the 2 of us, because we had different roles, but somewhat of a symbiotic relationship.
Yeah.
Yeah, it's great. And we appreciate the opportunity very much.
Well, as a former journalist, this is a great story.
I think it is. I mean, I think what you're trying to do is really valuable to the environmental community out there across the whole country. you know, because there are so many organizations, and it's so hard to start from ground zero. You know, boy, if you've got to start from ground zero and you have no idea where to go or who to turn to, that's tough. But if you've got a documentary or, you know, a manual or something that you can look at and go, okay, step one,
Well,
we can do that.
Yeah, and our first mission is give people hope.
Yeah,
Yeah.
yeah, absolutely.
Yeah.
Because Dominion's approach was, it's a done deal.
Oh, yeah.
Right out of the gate, right?
Oh, yeah. That's why they refused to even talk to us about alternative routes. I mean, I was just so dumbfounded that, you know, because the organization that I was thinking of earlier is All Pain, No Gain. And that and we should talk about that just a little bit. That organization's position was, let's get them to agree to an existing route, either a utility route or whatever. And we had people on Friends of Nelson that came up with a couple of very good alternatives. I mean, very decent alternatives that were in transportation corridors, that were in utility corridors, that were in railroad corridors, et cetera, et cetera, et cetera. And the position we were prepared to take was, well, if you're willing to do this, then, you know, we're willing to help you get people to support you. But they just thumbed their nose at us. And I've talked to people from Dominion who work there and who have talked to people up the ladder, and they were so sure that between their money and their political connections that they were going to get this brand new right-of-way. And that's what they really desperately wanted, was that brand new right-of-way. And they didn't want to, you know, deal with an existing right-of-way. It was very interesting. But anyway, back to All Pain, No Gain. I don't know how much you know about that organization.
Only a little. Yeah, but you were
Well,
closely.
I was kind of involved in
Involved.
that also. And their approach was a different approach, and I'm not sure that at the end of the day it was particularly helpful, quite frankly, because they funneled off, I'm going to guess, close to $500,000.
I heard it was millions.
No, it wasn't millions. I can assure you it was not millions. I would say maybe in the range of $500,000. And their approach was to take out newspaper ads, radio, TV ads in Richmond. I saw some in Charlottesville, where, you know, they were trying to set forth the negativity of the pipeline and, you know, the need to do something different. And that approach, like I said, it funneled off a lot of money, at least $500,000, that had they joined the Friends of Nelson and ABRA and played along in that supporting role, I'm thinking that maybe that money would have been better spent. I don't know. I think it's a 50-50 hindsight thing. I don't know. Tom Harvey was the head of it. I don't know how Tom feels. I'm sure he's happy that, you know, the pipeline's not here. But you know, it's an interesting question that can be raised about splintering of local groups, especially where, in this case, there were two splinter groups, in my opinion. The other big splinter group was something called Wintergreen. Millions of dollars available, political clout available. I was assured by friends at Wintergreen that when our current governor became governor, he was going to be very supportive of, you know, getting rid of the pipeline. Ha! That didn't work out too well. So, you know, that Wintergreen group became very insular. They looked out pretty much for just Wintergreen and the value of property at Wintergreen. But, you know, there were a couple of fairly significant donor organizations that were available to ABRA and to Friends of Nelson that, you know, that money just didn't flow into your coffers. Right. So what you did was truly a grassroots shoestring operation, and I don't mean that in a negative way, trust me, I really don't. But, you know, again, we're just so blessed and fortunate to have SELC and Greg and his team here, because without them, it never would have happened.